We will turn now to the first bill on our agenda, which is going to be House File 3477. Representative Long, and the motion here is going to be for House File 3477 to be placed on the general register. Welcome to the committee, Representative Long.
Thank you so much, Chair Liebling. Members, we should all be able to agree that when a citizen's constitutional rights have been violated, that there should be a remedy. The Constitution is fundamental to the fabric of our society, and each of us takes an oath to uphold it when we are sworn into office. Yet there is a gap in current federal statutes and case law that means many constitutional violations by federal actors fall through the cracks and don't lead to accountability. The bill I'm proposing today, the Universal Constitutional Remedies Act, would patch these constitutional holes by establishing a civil remedy when a constitutional right has been violated by a government actor. This mirrors what has been in place for state and local actors since 1874 under 42 U.S.C. Section 1983. These so-called Section 1983 claims have helped provide accountability for local and state actors when they violate the Constitution. But the federal government, in its wisdom, did not include itself in these claims. The concept of expanding these claims to all government actors, including federal, has been around for at least 40 years, and at least 6 other states have these laws in effect. This bill closely mirrors the language of Section 1983, except it applies to all local, state, and federal actors. This even-handed application is important to show that we are not discriminating against federal actors. While this idea is not new, the recent context of federal government immigration enforcement in Minnesota has made plain the need for this law. There has been bipartisan acknowledgement of the widespread violations of constitutional rights that we have seen in our state under Operation Metro Surge. Several GOP legislators have made that clear publicly as well, with one saying, quote, "Constitutional rights are being violated right now, and I can tell you that, and it's not okay." Courts have found such violations as well. They have found First Amendment violations, including retaliation for protected speech activities. They have found Fourth Amendment violations, including unreasonable searches and seizures. They have found Fifth Amendment due process violations, including depriving detainees of their right to counsel. A judge wrote of detention conditions, quote, "It appears that in planning for Operation Metro Surge, the government failed to plan for the constitutional rights of its civil detainees." But these cases were all for injunctive relief and not for relief for the harm caused to the individual citizens. When a citizen has had property damage, like their door being broken in violation of the Fourth Amendment, or physical harm in retaliation for free speech in violation of the First Amendment, or most tragically of all, loss of life in violation of the Fifth Amendment, there must be a remedy. And the public agrees. When asked, in your opinion, do you think federal officers and agents should be granted immunity from prosecution for any unlawful activity during immigration enforcement actions, the answer was overwhelming. 88% of Minnesotans said no. Federal agents should not be granted immunity and should be held accountable. And this bill would be far less than criminal prosecution. It's simply civil liability. In the 1983 context, those claims are not paid by the government employee, but by local or state governments. This does two things. It makes whole the individuals who were harmed, and it provides some accountability by encouraging governments to change their policies, such as better training their employees to follow the Constitution. This bill would apply not to a particular type of action or actor. It is not limited to immigration enforcement or even to federal actors. It would protect against constitutional violations by any future administration, be they Democratic or Republican. Put simply, if we believe in the Constitution, then we need to protect and enforce its rights. That has been available for state and local constitutional violations for 152 years. This bill would be an important step to apply the same protections to Minnesotans for constitutional violations by federal actors. I have 2 testifiers with me today, Madam Chair.
All right, thank you, Representative Long. So is it Harrison Stark is first? Welcome to the committee. Please proceed.
Thank you very much, Chair. Co-chairs, members of the committee, thank you again for the opportunity to be here today. My name is Harrison Stark. I'm senior counsel at the State Democracy Research Initiative at the University of Wisconsin Law School. And I'm also the author of an explainer that I believe is contained in the legislative record that provides a legal analysis for these kinds of laws, which are often dubbed Converse 1983, in that they are a state-created remedy rather than a federal-created remedy for violation of constitutional rights, or state damages remedies against federal officials. That explainer is quite long, so I won't repeat its content here, but instead just want to emphasize a couple points for the committee. The first is that, as you've heard, this legislation would fill a critical gap in our legal and constitutional landscape. Rights are only as strong as their remedies. And without a remedy, rights are not so much protections or rules, but are really just suggestions. While you can get a court order for rights violations that are ongoing, if a violation has already occurred, the primary way that the American legal system rights wrongs is to provide money damages. The idea is that you compensate the victim by making them whole and provide a financial incentive against the perpetrator for them not to continue to violate anyone's legal obligations or rights. It may surprise folks to learn that today there is simply no reliable path to suing federal officials for constitutional violations for money damages, even though you can do that against state and local officials. In fact, it is likely more difficult today in 2026 than at any other time in American history to hold federal officials accountable if they violate constitutional rights. And that applies across administrations and across constitutional provisions. It applies in the excessive force context, in the free speech context, in the Second Amendment context, in the religious liberty context. And the result is that victims of constitutional violations frequently have no redress after the fact, and federal officials have little financial incentive to respect constitutional boundaries. This legislation would fill that gap. The second point is that these laws, even though they are state-created, are not just consistent with the U.S. Constitution's Supremacy Clause, but really vindicate states' historic role in our constitutional system. They are consistent with the Supremacy Clause because they do not elevate state law over federal law, which is what the Supremacy Clause prohibits. Instead, they provide a path for vindicating federal constitutional rights. These laws also can't interfere with legitimate government operations, which is another Supremacy Clause problem, because they only focus on unconstitutional conduct, which by definition can't further the lawful objectives of the federal government. More than that, though, they really fit into a larger arc of states enforcing constitutional boundaries against the federal government. For centuries, state law was the primary mechanism by which individuals turned to vindicate their constitutional rights. And so, although these types of remedies look a little novel in today's legal landscape, they are in fact restoring a much older and storied tradition of states providing remedies for residents, no matter who violates their constitutional rights. Third, and finally, these laws are likely not preempted by federal legislation. It is true that many regular or traditional common law torts, like trespass or nuisance or things like that, must go through the federal regime of the Federal Tort Claims Act, but Congress left an explicit carve-out for any action that is brought for a violation of the U.S. Constitution, which is exactly what these causes of action would provide. I'd be happy to answer any questions from the committee. Thank you.
Thank you. Thank you very much. Megan Forbes, welcome.
Thank you, Madam Chair. My name is Megan Forbes, and I'm Senior Legislative Counsel at the Institute for Justice. We are a nonprofit public interest law firm that works to protect civil liberties, and we appreciate the opportunity to testify in support of this bill. This bill responds to a serious problem. When a person's constitutional rights are violated by federal officials, there are not meaningful legal remedies available in federal or state courts. Right now, if a federal official goes into your house and causes damage without a warrant, takes away a legal firearm, retaliates against you for exercising your right to free speech or freedom of religion, beats you, or even kills you, there's not much that you can do about it to protect your constitutional rights. You cannot sue them in most state courts, and you cannot sue them in federal court, and that's a serious problem. A right without a remedy is not much of a right at all. This bill restores a basic accountability mechanism that was once available at common law and under federal precedent, but that has since been largely gutted. It's an important fix, and it brings much needed reform. As has already been mentioned, a number of states, at least 6, have state causes of action just like this, and some of these laws have been on the books for decades. This bill creates accountability, which builds trust. Trust is a critical part of law enforcement. When people think that government agents can act with impunity, it breaks down that trust and makes us all less safe. It makes law enforcement interactions more confrontational and makes them less effective. Finally, I'd like to note that while this bill opens the courthouse door, these cases would still be challenging because of immunity defenses that are judge-made defenses that would continue to exist in the law. There's bipartisan legislation that also seeks to fix that problem that we think is worthy of consideration too. To wrap things up, we encourage the committee to support this bill and to stand with the Constitution and the state's right to enforce it. Thank you.
Thank you very much for your testimony. Okay, at this point, I'll see if there are any members of the public who wish to testify, and then we will move to the amendments that have been filed. Are there any members of the public who wish to testify on the bill? Two minutes? So, okay, welcome to the committee. We'd ask you to state your name for the record, and then you've got 2 minutes for your testimony, and we will let you know when the 2 minutes are up. Welcome. Please be seated.
Thank you, Chair Liebling. I have a disability that makes it difficult
That's
for me
fine.
to sit.
Okay.
My- Please don't interrupt my testimony. So my name is Dr. Roger Day.
Sir, we need to have you leave the room.
I don't understand this.
What's, okay.
Please don't touch me.
Sir,
Um,
we were advised that you were not to testify.
I
There he
am
is. So give him his 2
a,
minutes. Ma'am, we'll just let him testify, okay? 2 minutes. Go ahead.
my disability is a product of color of law assaults. I am a person under multiple color of law assaults from state and federal actors. And so this is a really important bill for me and for everyone. When someone is assaulted by someone acting under color of law, it doesn't just harm the person being assaulted. It harms the administration of justice and the exercise of the Constitution at large, and actually destroys our country. So in my case, it's mostly federal judges who have created false documents about the proceedings in which I've been involved that form the color of law violations. But there are a number of other state actors who are violating my rights in other ways under color of law. Too numerous to get into here. But again, the Metro surge has been the impetus for this law, but that's not the only kind of unconstitutional activity that is carried out by people under color of law. So I want to be really careful with this language, make sure it is all inclusive. But this is a law that's long overdue. Our state's citizens each need to have this kind of remedy so that justice can prevail for all of us. So I support this bill both in its concept and in its current form. Thank you.
Thank you, Dr. Day. Does anyone else in the public wish to testify? Okay. Yeah,
I'd just like to ask for a roll call when we're ready to do this on this bill.
okay, a roll call having been requested. We are going to take up some amendments, Representative Bliss. So you want a roll call on the bill? Okay. All right, so we do have some amendments, closing the testimony then, since no other person is wishing to testify. We do have some amendments in the packet. There's an A1 amendment. Does a member wish to offer the A1 amendment?
Madam Chair?
Representative Duran.
Madam Chair, I would like to offer the A1 amendment.
Amendment's been offered. Go ahead, please.
This would remove subdivision 2, removing the substantial concern around an agreement the federal law enforcement partners would have to enter into, well, when helping out Minnesota. So,
Okay. Any other, Representative Long?
Thank you, Madam Chair. So subdivision 2, the intent here was to have another belts and suspenders way for there to be a legal hook for federal actors when they are voluntarily entering into agreements with local governments to make sure that they are saying in those agreements that they are going to abide by the state and federal constitutions. It is not core to the bill, so I guess my question to Representative Duran is if I accept his amendment, is that make it more likely that the bill will move out of committee?
Representative Duran?
thank you, Madam Chair. I don't necessarily think that it's going to change the opinion of some of the people on there, but so.
Chair Scott?
Thank you, Madam Chair. And that's not the way we operate around here, the quid pro quo on the taking or, basing the passage of a bill on, hey, will you take this amendment? If so, then will you pass the bill if I take the amendment? That's not the way we work around here. And so you didn't even need to answer that question, Representative. So I don't like that means of operation. So thank you, Madam Chair.
Well, Chair Scott, I don't view that as a quid pro quo. I mean, this is a matter of, will this bill be acceptable to you without this piece? So that is absolutely, I'm sorry, not a quid pro quo. That's just off the wall, I'm sorry. But, if people don't want to be asked, what would make a bill acceptable to them, you certainly don't have to answer that question. But I don't think it's an illegitimate question to be asked in committee. Does anyone else want to speak to the amendment? Oh, Representative Steer.
Thank you, Madam Chair. So, Chair Long, are you aware that the subdivision 2 would end all agreements between the federal government and local agencies, Drug Task Force, Joint Terrorism Task Force, all those agencies, they would all come to an end?
Representative Long?
Thank you, Madam Chair. That's not the requirement of subdivision 2. Subdivision 2 requires that the federal government would have to agree to abide by state and local constitution in order to have those agreements. And my assumption is that the federal government would be willing to abide by the Constitution.
Representative Steer? Representative Fraser?
Yeah, I mean, that would be, thank you, Madam Chair, and thank you, Representative Long, for bringing this bill. That would be my question to to Rep. Duran, who's moving the amendment, is if we remove this subdivision, are we saying that we're removing it because we have fear that the federal government, whatever the operation is, whatever the collaboration is, that they are not willing to abide by the federal and state constitution?
Representative Steer?
Yeah, you said federal and state. So
Correct.
Federal has federal laws and state have state laws. So this is saying that federal law has to comply with state law, which isn't how it works.
Thank
Representative
you,
Fraser.
Madam Chair. But if we just remove, let me just say clear. But the concern is that the feds will say we are not willing to abide by state law.
Representative Steer?
I think the feds will stay with the federal law and the state will stay with state law. I don't think they're going to abide by state law. They're going to abide by federal law.
Madam Chair, may I?
Representative Fraser. and
So
then we'll
our
go to
state
Representative
constitution is pretty much in line with federal law. So what would be the concern?
Moeller. Okay, all right. I'm going to go to Representative Moeller.
Thank you, Madam Chair. And that was my question as well. We keep saying state law, but it's very clearly written in here that it's the Minnesota Constitution. And I feel very strongly that federal agents acting in our state should be following both the United States and the Minnesota Constitution to make it very clear that it's not talking about individual laws and statute books. This is our Constitution. And they should be following both constitutions. Thank you.
Chair Scott?
Thank you, Madam Chair. Representative Long, I'm just wondering, I know there are some other states that have adopted similar language. Has the federal government signed such agreements so far that you know of? And even going back, I mean, yeah, if you know the answer.
Representative Long.
Thank you, Madam Chair. Thank you, Chair Scott. I don't believe this language is in any other state law. This was our attempt to try to have another hook for having this be legally enforceable. But as I said, this is not the main thrust of the bill. And so I'm willing, in a gesture of hopeful good faith, to view it as a friendly amendment and accept it and hopefully that would get a little bit more to paying most attention to subdivision 1, which is the core and meat of the proposal.
Okay. Chair Scott? Any other discussion? Representative Duran.
Thank you, Madam Chair. Have you spoke to the stakeholders in regards to pushing these mandates to come into these agreements with the law enforcement agencies? Have you spoken to any law enforcement agencies about these, or what it would do, or what are the consequences for this?
Representative Long.
Thank you, Chair Liebling. I have not had conversations directly with law enforcement agencies. I'd love to. We're only in the second week of session, and this was a early bill hearing schedule, but would be happy to. But as I said, I'm happy to accept your amendment, Representative Duran.
All right, can we move to a vote then? All in favor of adoption of the A1, please say aye. Aye. Any opposed? Motion prevails and the A1 is adopted. There is another amendment in the packet, the A2. Does someone want to offer the A2?
Yes, Madam
Chair
Chair.
Scott?
The A2 is similar to a bill adopted in the Senate that Senator Champion put forth. It's very similar, and it just clears up the issue around legislating past the past by having a 6-year look back from the date of enactment and makes it only for cases of action, causes of action moving forward after the enactment date. So I would submit that for a vote, Madam Chair.
All right, Representative Long.
Thank you, Chair Liebling. Chair Scott, I would unfortunately oppose your amendment. It was in the Senate viewed as a technical fix, but I think it goes beyond that. It, as you state, would prohibit a look back, and given the testimony we heard earlier and the concerns that we have seen in our community with the stark increase in constitutional violations, I don't think that is appropriate. 6 years is the statute of limitations for torts violations in the state, and so that seems to me an appropriate limitation on these causes of actions.
Other discussion? Oh, Chair Scott.
Thank you, Madam Chair. I just had a question for Ms. Davis on House Counsel. Is that okay? Can I
Yeah,
go ahead?
please,
All right,
please.
thank you. I'm just wondering how common it is. I've been around here going on 18 years. I don't recall a lot of legislation bills that we pass that have a retroactive effective date, a look back of this nature. Can you enlighten me a little bit on whether that's common practice? Ms. Davis, thanks.
Ms. Davis.
Sure. Chair and members, Mary Davis from House Research. Effective dates can be retroactive in some situations. There are prohibitions, there are state and federal constitutional prohibitions in some cases against retroactive effective dates. For example, ex post facto laws that are criminal, and things that impair contracts. So those are considered by the courts. our judiciary doesn't keep track of, what kinds of things are passed or anything, so we don't have like numbers or anything like that. But retroactive effective dates are less common because of the various limits under state and federal constitutional provisions. But they do pass from time to time. There are civil law bills that have the occasional retroactive effective date. And the language that we use is similar to what is in the bill. Or if you're trying to make sure that it's not retroactive, we use the language that's in the amendment.
Chair Scott?
Thank you, Madam Chair. Representative Long, I hesitate, the reason for the amendment is I hesitate to go down this road of making law that's retroactive in nature. And I understand why you want to do it, but I just have a real lack of comfort in setting some sort of precedent to do that. So I would encourage the adoption of the A2. Thank you, Madam Chair.
Other members? Representative Moeller?
Madam Chair, and thank you, Chair Scott. I was thinking of a situation where I don't know if it was written to take care of situations that occurred in the past, and that's this sexual assault allegations, the civil liability for sexual assault cases. That was an example of a law where it was written in a way to open up the window of opportunity to go back in time and sue their abusers. So I just wanted to offer that as an example. I know that won't change your mind, but it came to mind. Thank you.
Representative Engen?
Thank you, Madam Chair. And this is a question more for the author, but how did we arrive at 6 years? Why not go back farther and cover the 3.1 million detained and deported that were under the Obama administration, including the 67 deaths that occurred in custody? Why not go back even farther?
Representative Long?
Thank you, Chair Liebling. As I stated, 6 years is the statute of limitation for torts, and so we mirrored that.
Thank you, Representative Long. Representative Engen, anything further? And of course, that does take us back into the Biden administration. So, I guess we'll vote on the amendment, but I'll give you the final word on it, Representative Long. But I just want to say that given the presentation that we heard, the unbelievable, unprecedented violation of civil rights in this state over the last few months, to not have this be retroactive is, to me, would be a travesty. I don't know if, it would have to go back 6 years, and I assume that we could even shorten that in terms of a look back. I don't know if that's something that's been considered. But to think about the things that have happened to Minnesotans, where, as was stated, if you don't have a remedy, you don't have any rights. And what do we do for someone whose door was kicked in without a warrant and without any exigent circumstances, completely illegally? What do we do for that person? What remedy does that person have? And without this, I think the answer is none. And that's really horrifying to me. So I certainly am not inclined to vote for this amendment. I'm going to vote no, and Representative Long will give you the final word on it.
I think you said it very well, Chair Liebling.
Thank you. All in favor of the A2 amendment, please say aye.
Aye.
All opposed? No. The motion does not prevail. The amendment is not adopted. And we have the A3 amendment. And does someone wish to offer the A3 amendment?
Thank you, Madam Chair.
Representative Hudson.
No, it's right. Sorry, Madam Chair, there's a little confusion as to which amendment is which, given the fact that there's two bills that have the same underlying language.
A3 for 3477.
Oh, is this the wrong?
A3 for 3477.
Yeah. Okay.
Okay. Thank you. Got that cleared up. So what this amendment would do is it would require state agencies, including the Office of the Attorney General, to absorb any costs related to the litigation that would surely result under Section 1. Pretty simple.
Okay. Thank you. Do you want to offer any explanation of why this is important?
Sure. Thanks for that opportunity. So obviously, if we're going to enact a policy that is going to require additional costs in order to cover litigation directed at the state, We don't want that to become a blank check for requests for appropriations in the future that result from litigation being directed at the state that in some cases may be frivolous or without merit. And so rather than have a path to endless requests from agencies to cover costs related to a law that we pass, we're saying that we are going to put a cap on the budget in the form that it's been appropriated by the legislature, and what you get is what you have to work with.
Representative Long?
Thank you, Chair Liebling. So if the concern is fiscal costs, then for the state, there is no difference for this law than Section 1983, so there shouldn't be any change from the state liability perspective. But I don't believe this is how we've handled large settlements in the past, and so I would oppose the amendment.
Chair Scott?
Thank you, Madam Chair. So two things. Then we need to get a fiscal note before this thing can move forward, just to make sure. Because in addition to what you're adding in this is state and local officials can be held under color of law. So those local units of government may also be sued. So we'd probably need a fiscal note from those people as well. So I support this amendment.
So I guess what I would say is, just from my experience, I think if we asked for a fiscal note, I think it would come back saying we can't possibly estimate this. You know, this is just that kind of a thing. I don't know if John Walls is in the room here. Oh, Mr. Walls. Can you speak to this?
Madam Chair, John Walls. Thank you. John Walls, House Fiscal Staff. I was unsure whether there would be costs attributable to this bill. I did request a fiscal note, but due to the just sort of lateness and seeing the schedule, it is not complete. I don't know that I anticipate it would come back with any costs. I'm just unsure, and there's been no response at this juncture.
Okay, thank you, Mr. Walls. So, you know, that being the case, I mean, I would not hold up the bill for that. I mean, if it comes back with a fiscal note, I mean, it is going to the general register, but I assume that if it comes back with a fiscal note, it would have to be re-referred to Ways and Means, clearly. But Representative Long?
Yep. Thank you, Madam Chair. So as I stated, the overlap for state and local governments is total with Section 1983, and so there shouldn't be any additional costs for state and local governments. And at least in the Senate, the Sheriff's Association said that it was duplicative of the Section 1983 for state and local governments. So I think that is your answer for whether or not there's additional costs.
Okay, thank you. Any other discussion to the amendment? Okay, seeing none, your final word then, Representative Long, is, I assume, was you're opposed to the amendment?
I am. Thank you, Madam Chair.
Okay, so all in favor of the A3 amendment, please say aye. Aye. Opposed? No. The motion does not prevail. The amendment is not adopted. So we are back on the bill 3477 as amended by the A1. So which removes Section 2, subdivision 2 of the bill. So is there any further discussion to the bill as amended? Representative Hudson.
Thank you, Madam Chair. Try to keep this concise, but there's a lot that needs to be said here. So I found it fascinating to listen to the testifiers claim that there's no path to remedy for constitutional violations at the federal level. Of course, we have the Bevins decision, we have the Federal Tort Claims Act. What is true, even though it was unstated, is that there are exemptions in there specifically for immigration enforcement. That's longstanding. And so the claim that this is something that other states are doing, yes, other states do have some form of civil action in place, but none of them, as admitted by the author, have this requirement for cooperation between the feds and the states when it comes to adopting or accepting this state-level liability. And there's no compelling the federal government to comply with that requirement in any of these other states. So I just want to be clear about that, is that there are existing federal protections, federal ways for you to seek remedy for violations of your constitutional rights. And we talked about the Supremacy Clause. Again, we have states that cannot impose a liability upon the federal government or federal officers while they're performing their federal duties. And that is because there are certain things that the federal government is tasked with, and one of those is immigration enforcement. And we have, again, we have the Westfall Act that speaks to that. And the impact of this, and I don't think we've talked enough about the part of this bill that requires any federal agency to agree to abide by state law in order to enter into an agreement with local and state law enforcement. That's really the crux of what the problem is here, is we're trying to get around the fact that the Supremacy Clause exists. We're asking the federal government to cede its supremacy to the state of Minnesota for the purpose of bringing litigation against federal officers that, again, is already dealt with at the federal level with the existing framework. And so you would not likely see federal agencies agree to do that, which means that state and local authorities would not just no longer be cooperating with ICE, but they wouldn't be cooperating with the DEA, the FBI, the ATF, DHS, DOJ, et cetera, et cetera, et cetera. Any joint operations involving law enforcement or enforcement of federal law would basically be stymied by this provision if it were to become law. And my last concern with this bill is that it seems to further the existing asymmetry between law enforcement that's out there trying to protect the public from public safety threats and activist prosecutors who commonly are able to just decide that regardless of whatever the police encountered or whatever crime is evident or suspected, that they're not going to prosecute. What this does is this elevates the level of scrutiny that already exists upon law enforcement while maintaining the broad prosecutorial and judicial discretion that has enabled people to dismiss cases, not prosecute, and ensure that people don't meet with accountability. I have no interest whatsoever in widening that existing asymmetry. We need to go in the other direction.
Thank you, Representative Hudson. I would just note that we removed the section that you just spoke about that you're concerned about, the section about intergovernmental collaboration agreements. That's no longer in the bill. So those concerns, they were heard, they are removed. Representative Scott, Chair Scott.
Could I respond?
I'm sorry, go ahead.
Thank you, Chair Liebling. I just wanted to point out that the Federal Tort Claims Act is limited to the common law tort claims and not to constitutional violations. And I'd ask if my co-presenter could maybe speak to the very strong limitations on Bivens claims if we have a 30 seconds.
Why don't we go to Chair Scott and then at the end, Chair Scott.
Thank you, Madam Chair. And Representative Long, another fear that I have with this as it's written is that it's going to get tied up. There are going to be lawsuits. And because I know we're here talking about the Constitution, but I think there will be constitutional cases brought against this law. And one of my concerns is that we've had past history under the DFL trifecta. We had 3 laws that were enacted that have now gone to court, and the taxpayers are left footing the bill for the arguments and for going up against the government. So just the PSEO issue alone is estimated to have cost the taxpayers around $3 million. And so this morning, I was on my way in, I was listening to the State Gov committee, and one of the things that your members were talking about is that we want to avoid situations where there are going to be constitutional challenges because it's expensive for the taxpayer. And so my concern is that we're allowing this to happen again, Because you're going up against the supremacy clause. That's a heavy lift. And I'm just not sure, maybe you can give me some comfort that those constitutional challenges, that this bill would prevail. And maybe your testifiers can give me some comfort that that is the case as well. But that's one of my concerns. Another concern I have is that the attorney's fee piece, and I apologize for not having an amendment to address that, but what I don't want to see is frivolous lawsuits brought under something like this, and because there's nothing at stake for the plaintiff if they lose. But there's everything at stake for those, for the defendants. So those are some of the concerns that I have with the bill. And let me ask you this too, because I really disagree with the fact that that there won't be a fiscal note to this, because you're scooping in state and local authorities in a way that they haven't been scooped in before by adding the Minnesota State Constitution. So let me ask you, and you're making them, you're holding them accountable for the actions that they take on a local level. So let's say that local city council, a council person passes a law, or the council does, that says we're going to be a sanctuary city, and then a private citizen is harmed by a criminal illegal alien. Is that under your law, under this, if this became law, wouldn't that city council be at risk of being sued under this law?
Representative Long?
Thank you, Chair Liebling. Chair Scott, to your first question, we worked very hard to make sure that this is as constitutionally sound as we can. We removed the language that is in the underlying 1983 around statutory violations, so that that would get around potential supremacy clause concerns. It's only focused on constitutional violations. We didn't do what some other states have done and focus on federal actors or focus on immigration enforcement only. This is applying equally to all actors, federal, state, and local, and equally to all claims. So we've worked very hard to make sure that this is as constitutionally robust as we can, and I'm confident that it would survive a court challenge if one came. I don't know that I could speculate on your hypothetical. I'm not seeing the constitutional amendment violation that you're getting at there.
Chair Scott?
Madam Chair, where's this bill headed afterwards?
It's going to the floor.
I'm going to recommend that it be sent to the State Gov Committee, because this does involve state and local governments, and they have not had a chance to see this bill, and I think that they should have a conversation about the effects of it on the state and local level.
Representative Long, so is that a motion, Chair Scott?
Yes, that's a motion. If it's appropriate at this moment, it may not be appropriate until later, but I'll let you make that call, Madam Chair. But
Well, I think we could dispose of that right now, since we're talking about it.
and I'd like a roll call, please.
Okay, Representative Long?
Yeah, I don't oppose that.
You don't oppose it? Okay.
Nope.
All right.
Then I'll withdraw the roll call.
All right, so, well, okay, so we'll just change, what we'll do is we'll just change the motion at the end then, Chair Scott, if that's okay with you. So the motion at the end, when we vote on the bill, will just be to send it to, what is it, state and local government? Okay. Okay, remind me if I forget. I'm sure you will. Okay. So we won't vote on that at this second, but we'll just add that to the motion, unless members wanted to, I don't know. Okay. But any objection to proceeding that way? Let me put it that way. Okay, so we'll just change the motion at the end to send the bill to state and local government. Okay. Who do we have? Representative Curran.
Thank you, Chair. And thank you, Representative Long, for bringing this bill forward. I know that a lot of the context around this specific bill language today has been focused on activity over the last several months in Minnesota. Wherever folks stand on those particular circumstances, I think when I'm looking at this, what's really important to me is How have these things occurred in the past? What's different now? And how might your legislation help people in the future under any administration? And the topics that we talk about in the Judiciary Committee, I always want us to bring that lens of under a different governor with different control at the state capitol, with a different president. How are the laws that we're passing, are they going to be helpful under different administrations? And I would hope, at least I was hoping coming to this committee today, that there would be sort of this, and maybe there is, and it just hasn't been clearly stated, but I would hope that there is an underlying agreement in the Judiciary Committee that civil and constitutional rights are something that we need to protect regardless of who is in charge. And I think we can all think of different situations where an administration we don't like is in charge that may do things to us that we feel is unconstitutional. And it's our job, regardless of party, to protect those rights. And so that's how I see your bill. I understand that there's a lot of emotion given the very serious events that have happened in our state. But I do want to take this to the context of what it means for the greater good, in that the Constitution historically seemed to be pretty clear in the past. And unfortunately, it just isn't anymore. What I'm hearing, I'm really disappointed to hear from folks who at one time or another have been sworn to uphold laws, question whether or not they need to do that. If you're not sure whether you need to enforce and follow state and federal laws, you have no business trying to enforce any of them. When you enforce laws, it's a very specific separation of powers that you don't get to decide what the laws are that you're enforcing. That's why we're here. It's a checks and balances system. So I understand that there are some folks at the table who are saying from experience, we may be used to working with federal agencies who disregard the Constitution in pursuit of their duties or orders. I just want to make very clear that when we're talking about legitimate law enforcement activity, not just here in Minnesota, but in the United States, unconstitutional law enforcement activity, unconstitutional activity on the part of a government entity is inherently not legitimate. But what your bill does is give people some accountability, a remedy for that. And I know Chair Scott had mentioned, what are the stakes for somebody? Unfortunately, the violation itself is the stake. It's too late. The accountability, though, is the remedy, and it's something that we can offer. And I wish that we didn't have to sit here and write laws that say, yes, even if you're in the federal government, especially if you're part of a government entity, you absolutely need to follow the Constitution in everything you do. I wish we didn't have to write a bill like this, but it has become very clear, especially clear in this committee, that it just might depend on the whims of an administration who's in place at the time to decide if we do in fact need to follow the Constitution. I find that horrifying. I think anyone of any party would find that horrifying if the tables were turned. True accountability is not only willingness to face consequences, but to support and encourage accountability systems for the people we represent. And so because the Constitution is meant to protect people, the people that we are all here to elected to represent, the Constitution is there to protect them. In my role as a government official, I cannot suppress those rights. That goes against what I was sworn to do here. I feel strongly that we are all elected here to uphold those rights. And accountability means that we're willing to bring solutions to the table as government officials and not take them away from people. So I really appreciate that you're bringing this bill, and I hope that folks can, if they don't get there today, can at least get around to agreeing that no matter who's in charge, we have got to uphold constitutional rights, no questions asked. Thank you.
Thank you, Madam Chair. Sometimes we make laws in regards to a good faith effort in regards to what we want to do, but don't necessarily think about the consequences that come from our actions sometimes. Would this bill have an impact on current qualified immunity for our state peace officers?
Representative Long.
Thank you, Madam Chair. Thank you for the question, Representative Duran. No, the bill does not address qualified immunity. As my co-presenter mentioned, there is a separate bill out there that does.
Representative Duran, anything further?
So this bill would have no issue with the qualified immunity at all, what you're saying right now?
Representative Long?
Chair Liebling, Representative Duran, this bill does not touch any qualified immunity precedent.
Okay. Thank you. Okay, final word, Representative Long, and if you want to have your presenter, we need to move, we're way behind, but.
Thank you. I'll
Go
be
ahead.
very brief. I just want to bring us back to what this bill does, which is that it allows Minnesotans the ability to enforce their own rights when their constitutional rights have been violated. And so it is about accountability for constitutional violations, which is something that we all in this room should be able to agree is a right that we want enforced, and 88% of Minnesotans agree. I have trying very hard to work on this in a bipartisan way and get to a place where we could move this forward together, because this is not about any one administration. This is not about any one party. It's about enforcing our constitutional rights for all. I've accepted an amendment to the bill in good faith. I'm happy to have the bill move to state government to have further conversations, and I ask that it move forward.
All right, thank you, Representative Long. So a roll call has been requested, so I will renew the motion on behalf of Representative Long that House File 3477 as amended be re-referred to state and local government. Correct? Got it?
Yes.
Okay, and the clerk will take the roll.
Chair Liebling.
Aye.
Liebling, aye. Chair Scott.
No.
Scott, no. Vice Chair Finke.
Aye.
Finke, aye. Vice Chair Hudson.
No.
Hudson, no. Representative Bliss.
No.
Bliss, no. Representative Curran.
Aye.
Curran, aye. Representative Duran.
No.
No. Representative Engen.
No.
Engen, no. Representative Feist.
Aye.
Feist, aye. Representative Frazier.
Aye.
Frazier, aye. Representative Mahmoud.
Aye.
Mahmoud, aye. Representative Mueller.
Aye.
Mueller, aye. Representative Rarick, excused. Representative Steer.
No.
Steer, no. Seven and six, but there's no GOP.
Yeah. Yeah, there are 7 ayes and 6 nays, but because we are, and Representative Rarick is excused, so without a majority, the motion does not prevail. Thank you very much, presenters and Representative Long.